welcome to the last episode of PLA today, or for this year, actually. So thank you to Nick and to Bruno and obviously all our viewers for the questions. And we hope we've added a great amount of value and knowledge to all our listeners and viewers. We've got obviously 2 more questions that we'll be finishing off with this year. And one of them will be for you, Nick, and then the second one will be for Bruno. The first question is from Facebook and is from Moms, and it says that I have entered into a lease agreement, and in June 2023, an agent informed me that the tenant said he's leaving the following day to the UK. He's leaving his 2 children with the relative, and his wife is already in the UK. The lease was expiring in July, but they asked for a renewal, which I refused. I can only give them until end November for the children to finish up with exams, and then obviously to go back to be back with them. He said his relative wants to stay for longer until end November, and I am refusing to extend for his relative as well. I was told he came back from the UK in August, and 2 weeks into the second week in November, said he's not moving as he has not found an alternative accommodation, and he also ran to his lawyer and sent an email which was titled PI, which is the Prevention of Illegal Eviction. He refused to move, said he will move end of March. My lawyer proposed that we start an eviction process. And then the question towards the end is obviously, can I request the court to grant judgment against the tenant to pay for the lawyer costs?
Okay, perfect. So legal costs. Obviously, this is one of those things that everyone who approaches a court has a question about legal costs. Am I going to get my costs back? How does that work? Okay. So to start off, the advice that the writer has received from their attorney, I believe, is to be correct. Okay, it seems that this tenant is indicating that they're not going to vacate. They're pushing the date back that they're going to get out of the premises. And in the circumstances, the correct move is to proceed with an eviction if you don't want them in the premises. Okay, it seems to me that there's nothing preventing them from doing so at this stage, because there might have been an extension to November, but now we sit in December, and there was no agreement to allow them to occupy the premises any further. So the correct step is to eject them if they are refusing, which it seems they are, to vacate the premises. So that's absolutely correct. Then it comes to costs. Now, the basic standard way costs work in legal proceedings is that costs are something that the court awards to a particular party within its own discretion. Okay, so people have this thing that I'm going to get my legal fees back, and I always like to be very careful, because a court is the one who decides who pays costs and how much those costs are ultimately going to be. Okay, and what attorneys have done, and you'll see this in most lease agreements, is most lease agreements include a provision which relates to costs and says that one party who is instituting a proceeding against another, or some lease agreements which are a little bit geared in the landlord's favor, will say that the landlord is entitled to costs. It will say it's can be claimed by one particular party. I just want to set out from the start, although your agreements might say that, costs still lie in the discretion of the court. It's very common that if you are successful in your court application, that the court will grant you costs. That's not really a problem, but it's still within the court's discretion. It's absolutely not guaranteed. Okay, this is mostly just a consideration for your attorney to consider, because the only time that a court is really not going to grant you costs if you are successful in your application is if there is conduct by your attorney which they disapprove of. So you have not performed correctly or fast enough, or you've really done some delaying tactics that the court doesn't like, they may then not grant you costs, and really your attorney shouldn't get into those particular spots. With regards to cost provisions, this helps us because now the court is going to read that cost provision and say, well, this agreement allows me to grant costs in the circumstances. It's not a crisis if your agreement doesn't have such a clause. It's still within the court's discretion to grant costs. But a clause within a lease agreement can assist in getting what is called a higher cost scale. So in law, there are a number of cost scales, okay? And scale simply means that you can expect a little bit more for a particular piece of work. So the easiest way for me to explain this is a lowest cost scale per a written page that your attorney's done. Okay, might be 10 Rand, and then a higher scale might be 15 Rand, a higher scale, 17 Rand. Okay, so that's what I mean when I say scale. Okay, and either you got your normal party and party scale, attorney client scale, and there's another scale which we'll have a legal debate over it, Bruno and I, whether it exists or not, but we call it the attorney and own client scale. And that's just the scale which basically you try to claim all of your legal. So in terms of this particular question, I'm not sure whether there was a written lease agreement in place. It isn't stated specifically, but it alludes to the fact that there was. Okay. And then the question is there a cost clause in terms of that particular lease agreement, which you can rely upon? All right. As I say, even if there isn't a particular cost clause in the lease agreement, your attorney is still in a position to claim the legal costs for having to go to court. It's going to be on the lowest scale possible, but it can be claimed. Okay, and ultimately, it's the discretion of the court to decide whether you are entitled those costs for bringing the application in the circumstances. Okay, so as your question, will you be able to get the tenant to pay the lawyer's costs? In theory, you can ask for costs against the tenant. Now, here's the way reality and legal work differ. Okay. We claim costs. I can guarantee you, Bruno and I claim costs in every single one of our applications that we ever bring in a court. Okay, on a higher scale if it's necessary. Okay, and we have got hundreds of orders, each of us granting cost orders against hundreds of different tenants who have refused to vacate premises. And I'll speak for myself on this particular one. I think if I've collected my legal costs back from 5% of those tenants, I think that would be a gross overestimation. Unfortunately, the reality is the writer might be lucky in this particular circumstance, but if you take a circumstance where you, for instance, have a tenant who is unable to pay their rental and they're not meeting their payment obligations, okay, and this is a normal rental, it's a person who in their premises, they've got maybe a couch and a TV and a toaster. The chances of you recuperating your legal costs ultimately from the tenant are very, very low. Okay. It's very unfortunate because in theory, they should pay for all your legal costs and you should be, rectified for having to incur the legal costs. But ultimately, in reality, it's very difficult to get those legal costs back from someone because they're not going to pay it willingly. And if you do really want to pursue the legal costs and go ahead and attach their assets and sell them, unless you're working with, commercial tenants sometimes have a really good, attachment value and there's some value in the assets they own. The real trick with legal costs when it comes to execution of assets of an individual who's living in an apartment, no one wants to buy a second-hand couch or a second-hand bed. You're going to get a few Rand for that, and it's very unlikely you're going to eventually reach what legal costs you expected. So in theory, your lawyer can, absolutely, and there's nothing wrong with that. He really should claim legal costs in his application. I just want to warn people of the realistic, recuperation of those costs that we experience on a day-to-day basis.
Just a quick one. I don't see from the question, we're assuming that the tenant hasn't paid their rent. But I don't see from the question whether he has or not. It just seems like the tenant's going, listen, I've got nowhere else to move, so I'm staying. Yeah. With the possibility that he's continuing to pay the rent, he's just refusing to vacate the property. So on that note, the only thing I want to add, look, it's unlikely. I mean, I've never seen something like that really happen, and it's like an incredibly good rent. But if that is the case, then he's not in arrears with his rent, which means that you may possibly have recourse against the deposit for any legal costs, assuming that he's not in arrears with his rent. So, just throwing that out there in case that, even remotely applies. Yeah.
So thank you very much, Nick.